I'm Drew Stevenson, and this is a lecture about the case MCI Telecommunications Corp versus AT&T Company, a U.S. Supreme Court case from 1994. And here we're talking about Chevron deference, textual analysis, and structural inference. And for my students, keep in mind, this is not a lead case in my administrative law casebook. It might be mentioned in the notes. It may help my students understanding how Chevron is applied or the Chevron legacy, so to speak, because it's definitely an administrative law case. It is a lead case in the casebook I use for my Statutory Interpretation and Regulation, or Leg-Reg class. And what you should watch for here is, remember, Chevron has two prongs. Step one, where the court asks if the statute is clear or ambiguous, and then step two, where they ask if the agency's interpretation is reasonable. And a lot of the litigation actually focuses on step one, because if we get to step two, the agency is almost always going to win. And so what happens is the parties end up disagreeing about whether the statute is ambiguous. And you might think that that wouldn't be something that people would disagree on, like whether a word is clear or ambiguous, but that's exactly what happened in a lot of these cases. And this case illustrates that rather nicely. So let's go back and look at the case and see what happened. Section 203 of the Federal Communications Act requires phone companies to file their rates with the FCC. That's a Federal Communications Commission. Now, during this filing period, companies may not charge more or less than the rate that they filed. Section 203 also contains other more specific provisions, including one that's important for this case that says that the FCC may, in its discretion and for good cause, modify any requirement under Section 203. And that word modify is what this case is all about. What does modify mean? Does that mean drastically change, or does that mean make tiny changes too? And that's where we get into a disagreement here. And so the FCC decided to invoke its authority to modify the requirements of Section 203 in order to exempt long-distance carriers other than AT&T, which was still the dominant carrier, from the filed rate requirement. In other words, everybody gets an exemption except one company. Now, for my students, I have to just explain a little bit of social context here. In the old days, we had, when people had landlines for phones before the era of cell phones, local calls, like within your area code, were free typically. But if you called another area code, even another city in your state, and definitely out of state, it was a long distance call and was much, much more expensive. So local calls were free and basically unlimited. And then anything outside of your area code was much more expensive. And for many decades, the Bell Company, or AT&T, they were had basically a monopoly on long distance calls. And the federal government in the late 80s, early 90s started to take moves to break up the industry and allow competition and break up the monopoly. And this case is in that context. And so what the FCC wanted to do, now we had a few other companies had started and were trying to get going in the industry, and they kind of were having trouble competing because AT&T had been so dominant for so long. So let's go back and see what happens here. And the FCC basically wanted to give a break to everybody except AT&T and allow them to adjust their rates to promote more competition in the market for long distance phone service. And the idea was that giving competitors more flexibility in pricing, sort of month to month, makes it easier for them to challenge the dominant carrier. And this would lead to more competition and lower prices and ultimately better services for consumers. The more competitors we have in the market, in theory, the more they will compete to offer a better product for a lower price. Now, this is a Chevron case, and the central question is whether the FCC's decision can be characterized as a decision to modify a Section 203 requirement. And just to make sure you don't get lost in the forest here, remember Section 203 requires that long distance carriers file what their rate is going to be, and then they're stuck with whatever they file. And then another section gives the FCC some freedom to make modifications or basically exceptions to the rules. And what they were doing was saying that filing and locking in your fee rule doesn't apply to anyone except this one company. And Justice Scalia wrote the majority opinion, and he said you can't do that. Basically, the agency is going to lose. Now, notice that the agency isn't one of the named parties in your case. It's really about the dominant carrier, AT&T, and the first runner-up that was the earliest competitor, which was MCI. And his opinion raises two related arguments about why the FCC's decision is inconsistent with the statutory text. The primary argument is that the ordinary meaning of modify, as shown by dictionary definitions, means a small or incremental change rather than a major or fundamental change. Now, for my students, remember, Chevron has two prongs. First, we ask, is the statute clear or ambiguous? And then if it's ambiguous, we ask if the agency's interpretation is reasonable. Now, if we get to step two, the agency almost always wins because that's such a low threshold to meet, to satisfy. And so when we have litigation, high stakes litigation like this, where there's millions, billions of dollars at stake, the parties are going to kind of dig in for trench warfare at Chevron step one, fighting about whether the statute is ambiguous or clear. And this can be a little counterintuitive, but a lot of the Chevron cases are really about Chevron step one and whether a word is clear or is subject to several meanings. And now, Justice Scalia, this is a period when he was using dictionaries, quoting dictionaries a lot in his opinions. And part of that was because of his championing of the textualist approach to interpretation, right? And so we're going to know what the statute means because we can look the words up. But he also uses dictionaries a lot because of Chevron to show, I looked it up in the dictionary and the meaning is clear. And I want you to think about the sort of mental trick or rhetorical trick that's happening here for my students, that we're basically saying, okay, how do you prove a statute is clear? I'm sorry, a word has a clear meaning instead of being ambiguous? Well, start quoting the dictionary and say, see, it's right there in the dictionary. It's clean. It's clear as day. And if you wanted to show it's ambiguous, you would talk to a linguist who would say, well, the way words are used in conversation and written communications and such is very nuanced. And there's a big range of meanings once around the edges of words. So Scalia kind of takes the Chevron case and turns it into these dictionary wars on the Supreme Court, where he's arguing, nope, the meaning is clear because we looked it up in the dictionary. And what the agency is trying to do is they're arguing it's ambiguous by arguing for a really far-fetched interpretation of this one word. Okay, so let's go back and finish up. The court decides, the majority is very skeptical that Congress delegated a massive fundamental policy decision to this agency. They think this is a big deal to single out one company that still has to comply with the statute, and then the statute, the filing requirement, basically doesn't apply to anyone else. They have to file, but they're not bound by what they file in terms of the rates they charge. And so the court construes the statute to forbid the agency from claiming such broad discretion. And I hope you hear echoes of the non-delegation doctrine here as we talk about this case. For those of you who are looking for a great quote to highlight in the case, here's one. It is highly unlikely, Justice Scalia writes, that Congress would leave the determination of whether an industry will be entirely or even substantially rate regulated to agency discretion, and even more unlikely that it would achieve that through such a subtle device as permission to modify rate filing requirements. Now, he has a secondary argument here, which is that it's unlikely that Congress would have delegated such sweeping authority to the FCC in such a subtle and cryptic fashion. So he starts with his big argument is, we just don't think that Congress would have told the FCC that they can basically deregulate the industry for everybody except one player. That's kind of a big delegation and a big ask. And And if they were going to do it, then he says they should have made it really clear and not done it with such a passing reference like the word modify and say, by the way, the FCC can modify the rules. They think that that was for making minor incidental exceptions. So he concludes that the court, because of this, can be this sort of structural argument, can be more confident that the statute means what the dictionaries indicate. In other words, the FCC is going to lose, and therefore, by implication, MCI loses, and AT&T is going to win on Chevron step 1. So now let's talk about what this says about textualists and what they do with Chevron. This case highlights the fact that despite general agreement that Chevron deference is not appropriate if the text of the statute is clear. In other words, we don't give Chevron deference when the statute is clear because the agency just has to do what the statute says. So if it's clear, then there is no room for interpretation from the agency. We don't care. We're not going to ask if the agency's interpretation is reasonable. The statute's clear. That's the idea. And but there are major differences in the way jurists might determine the required degree of textual clarity. So the prevailing view, I think, among law professors is that textualists are less likely to defer to agencies under Chevron. And that does seem to be the pattern in a lot of cases, because they're more apt to discern a clear meaning in a statute that might strike other interpreters as ambiguous. So if you see ambiguity, textualists are sort of predisposed to think that the text is clear. And that means that they are more likely to go against the agency at step 1 of Chevron. And note again the court's heavy reliance on dictionaries in this case. It's really striking, right? I mean, these dictionary authors are not even judges, and we're using them kind of tallying up how many dictionaries say one thing or say the other to decide major cases by the high court in our legal system. But note that there may be disagreement even among textualist judges in this cases. So here we want to talk about how you could be a textualist and actually still think that we should give Chevron deference. So some textualists like Justice Scalia are very confident that they can wring clear meaning from most statutory texts. But other textualists might actually find that information from the text itself runs out quickly. So you could like textualism in theory, but realize that when you look at the text itself to start with, that it leaves a lot of unanswered questions, that there's a lot of statutory silence on issues where we maybe think that the agency was supposed to fill in the gaps. And so these latter type of textualists actually maybe even more deferential under Chevron to agencies, for they see fewer legitimate tools of statutory interpretation to deploy at step 1. In other words, the more you think everything is clear, the more you're going to decide, well, every statute is clear, so we never have to get to step 2 in Chevron, and so we never have to defer to the agency. Now, on the other hand, let's talk about non-textualists, right? They might find statutes have clear meaning at Chevron step 1 because they're willing to look to other sources to clarify a word like modify that could have a range of meanings. So they look to it. So some jurists might say at step 1, but I looked at the legislative history and I looked at the preamble and I looked at other law review articles and things at the time. And so therefore now the statute is clear as day to me. So therefore, again, we don't even have to proceed to step 2 and ask what the agency's interpretation was or whether it's reasonable. Okay, that concludes our lecture about MCI Telecommunications versus AT&T.